Hi, welcome to Property Wais Pinoy. I am Attorney Donna, your property lawyer. Last week, we talked about who can own land in the Philippines, and you can watch that video here. Now, if you're a foreigner who's planning to invest in the Philippines, this video will answer all your questions, so make sure you stay tuned until the end of this video. We will answer the most important question as to how can a foreigner own properties in the Philippines. But before we dive in, don't forget to hit that subscribe button and ring the notification bell so that you don't miss out on all our informative content. Let's get started! Now, we know that as a general rule, land ownership in the Philippines is limited for Filipino citizens and corporations. So that means foreigners are not allowed to own lands in the Philippines. However, there are certain exceptions. So what are the exceptions? Number one, foreigners can own land in the Philippines through succession, and that is provided under our 1987 Constitution. Article 12, Section 7 states that, save in cases of hereditary succession, no private lands shall be transferred or conveyed except to individuals, corporations, or associations qualified to acquire or hold lands of the public domain. The most obvious example is for a foreign spouse who can inherit from his or her Filipino spouse, or even a child of a Filipino parent who has acquired foreign citizenship. That child can inherit from the Filipino parent. But remember, this exception is only applicable for intestate succession. What do we mean by intestate succession? That means when the person did not leave a will, so that's the only time that the foreigner can inherit via succession. When it comes to testamentary succession, or when a foreigner is named in a will, that is not allowed because that would be a circumvention of the prohibition. Are we clear on that? This is the only exception when a foreigner can own land in the Philippines. This ruling has been highlighted by the Supreme Court in the case docketed as Krivenko versus Register of Deeds, which was decided in 1947. Now let me tell you the story. In that case, a Russian man bought a residential lot and he wanted to register it under his name. He was well aware of the prohibition. His position was that since he bought a residential land, then it does not fall under the prohibition which refers to public agricultural lands. The court clarified that the term public agricultural lands refer to commercial, industrial, and most importantly, residential lands. The public policy for this prohibition is to preserve Philippine lands for Filipinos. Makes sense, doesn't it? Land is a finite resource, and unrestricted foreign ownership could lead to an imbalance, which would potentially drive up prices and make it difficult for average Filipino citizens to own their own land. It is public knowledge that despite this prohibition, this has not stopped foreigners from investing land in the Philippines, right? And I don't blame them, because investing here can give you good returns for your money. However, you need to make sure that you are protected and you should be property wise.
Next question. For foreigners who are married to their Filipino partners, what are your rights over the properties that you have acquired during the marriage?
Yes, you do have rights over the property since it's a conjugal property. The foreigner's name can be included in the contract of sale or the deed of sale, but then when it comes to registration before the Register of Deeds, they would not allow it to be registered with the foreigner's name. So it would still have to be registered solely in the name of the Filipino spouse. And the foreigner will still need the explicit permission of the Filipino spouse when he or she decides to sell the property to another, because the Filipino spouse is still the actual registered owner of the property. However, here's a valuable tip for you to be a property wise investor. Are you listening? Whenever you decide to build a house or a building on that land, that building can be registered under the foreigner's name, because a foreigner is allowed to own buildings in the Philippines. You got that tip from this Property Wise Pinoy channel. And how can you do this? You just register the building with the assessor's office in the municipality or city where the land is located, and your name can be reflected in the tax declaration. Now, the next question that foreigners would be asking is, what if I already have a special resident retirees visa or a special investor residence visa? Does that qualify me to own a property in the Philippines? Does that entitle me to own land in the Philippines? I'm sorry, my friend, but this type of visa only entitles the holder to the following purchases. Purchase, acquire or own a condominium unit, enter into a long-term lease of a house and lot or a townhouse for a period of not more than 25 years, or purchase, acquire, or own golf country club shares. But hey, that is still a good option because that entitles the holder to reside in the Philippines with multiple entry privileges as long as the requirements of the visa are fulfilled. There is still another avenue for foreigners to enjoy land in the Philippines, and that is through leasehold rights. Foreigners are allowed to lease land for at least 25 years and renewable for another 25 years. That is a long-term lease. And here's another property-wise tip for you. You can have the contract of lease annotated on the title so that it will serve as an encumbrance on the title, which means that the property owner cannot sell the property without informing you or without rescinding the contract of lease with you. And the last, but certainly not the least option that a foreigner can explore when you want to invest in a property in the Philippines is buy a condominium. That is actually the most common way for a foreigner to own property in the Philippines. Under the Condominium Act of the Philippines, which is Republic Act 4726, foreigners are allowed to own and buy a condominium unit as long as the foreign ownership of that project does not exceed 40%. Wait, does that mean that since foreigners are allowed to own a condominium unit, they can also own the land where that condominium is built? No, not really. The land where the condominium is built is not owned by just one person. It is owned by the condominium corporation. And that's why there is still that requirement that only 40% can be sold to foreigners while 60% must still be owned by Filipinos. For lands owned by the condominium corporation, we will have another video on this series about condominium ownership. I'm sure you have loads of questions. So in conclusion, while outright land ownership is generally restricted in the Philippines, there are still exceptions and there are other avenues that you can explore. But it is crucial to be aware of the legal nuances and for you to seek professional advice before investing. Thank you very much for joining us on our Property Wise Pinoy channel. If you found this information helpful, please give us a thumbs up sign, share this with your friends and your family, and please post a comment or your questions below and we might be able to answer that in our next videos. Don't forget to subscribe for more insightful content. And here's a teaser for you. For our next video, we will answer the question, what are the rights of former Filipinos in terms of land ownership? Until next time, stay curious and stay informed and be a property wise Pinoy. Bye-bye.